Thank you.
May it please your Lordship, your Ladyship. A couple of matters to pick up from this morning very quickly. My Lord Sales asked me what was the position prior to GRID going into the GRT. That's taken from Susan Wang's evidence in this matter, paragraph 20, page 437, where she says the shares of the holding companies, and GRID was one of those, were entrusted to Mr. Hung. So that's the evidence on that. The second point, my Lord Richards asked whether there was any writing on what the purpose of the types of clause like clause 15 are, the absolute and unrestricted, unfettered powers. We had a quick look in James Kessler's book on drafting trusts and will trusts, paragraph 7.10, it's the 14th edition, where he said they're included for the purpose of making it obvious to the layman that it is the trustee and no one else that has those powers to exercise, but it's absolutely clear that they don't allow a trustee to act improperly.
Yeah. Maybe just here we are.
So, my Lords, my Lady, we were on the purpose or the substratum of the original trust, and I was being asked, well, where do I get it's for the members of the Wang family from? My Lords, my Lady, we've set out 6 reasons in our written case, paragraphs 34 to 40, to support our case in that regard. It's at pages 1763 to 1766. And, of course, all we have to establish in this case is that it was not within the contemplation of YC and YT Wang when they created the GRT, when the GRT was created, that the GRT trustee would use its powers of addition and disposition to distribute 100% of the trust assets to the Wang Family Trust. So whatever the edges of the substratum may or may not cope with, what we have to show in this case is simply that what happened was well outside them, or was outside them, and we submit that we can certainly do that. The giving of trustees power to react to future circumstances, like the power of addition and exclusion might be regarded, does not give them the power to change the trust entirely. As Mrs. Russell and Graham put it in their article, page 2936, this breadth, that's of the power, should not be taken to mean that the power can be used in a way which does violence to the beneficiaries and displaces their interests completely. And yet that is what has happened in this case. In the interest of brevity, may I just simply give your Lordships and your Ladyship the references to the other cases which we say establish the proposition which we put forward, that the scope of the power is limited by its purpose. And they are Mr. Justice Millett's decision, as he then was, in Ray Courage pension schemes. That's cases at page 4853, and particularly he held at 4854 that the amendment in that case would manifestly alter the main purpose of the schemes and be ultra vires. And I'd also commend page 4863D and page 4868 at H. And also the Society of Lloyd's case, page 2444, which we referred to in our case at paragraph 28.2, and the Bank of New Zealand case, at paragraph 18, which is at page 3121. Also, Mr. Justice Warren's decision in PNPF, where he goes through the amendment in that case, both through the lens of construction, then through the lens of implied terms, and then through the Hole and Garnsey lens, as he describes it. His heading is Hole and Garnsey. And he points out that what can reasonably be considered to have been within the contemplation of the parties imports an objective test and states that it's consistent with descriptions of the restriction on the scope of the power to alter the objects of the purpose of the trust. It says the amendment must not change the whole substratum of the trust or its basic purpose.
And I'm sorry, I missed the page number. If you
So,
could,
Lord, that is at page 4652.
thank you.
And the bit that I've just referred to, or rather it's the analysis starts at paragraph 144, 4652, and yes, that's where that is, and it's set out in our case at paragraph 52.
Thank you.
And also the majority of the Court of Appeal, which were Lord Justices Lewison and Peter Jackson in the British Airways case, and that's at page 2045. They determined that an apparently unlimited power of amendment did not permit the trustee to arrogate to itself the responsibility for designing as opposed to simply managing and administering the pension scheme. Now, does Kearns and Hill affect any of that analysis? Because that's the case on which my learned friends rely on, and our answer is no, it doesn't. Kearns and Hill was not a case about the alteration of the substratum of a trust at all. As Justice of Appeal Morn said at page 2576A, if there was a substratum in that case, it was the benefit of the descendants of a named person, like in our case, whose interests were being actively promoted by the amendment, rather than diminished. So Kearns and Hill is not a complete answer to our submissions that there is a substratum rule, as my learned friends submit. Now, if I can move on to the construction point in relation to person and clause 8. The first point is that we say that the definition of person the context does not permit it to include the trustee of a purpose trust for the purposes of clause 8. And the following indicia are relied on for that submission. Firstly, there is no express reference to a purpose in clause 1.6, the definition clause which defines person. Secondly, as a matter of context, the Wang Family Trust was set up on the same day, and yet neither it nor its purposes were included in the definition of person. It, in fact, uses the same definition of person as is used in the GRT, and yet deals with purposes entirely separately and differently. And the Wang Family Trust is at the relevant clause, I think, is at page 392. And the other indicia arise out of clauses 3, 4, 9, and 19. So, no, 392, I'm sorry, page 392 is the incorporation of the statutory powers, but on the basis, this is in the WFT, but on the basis that beneficiary is to be read as purposes. You'll find the...
Sorry, which provision did you say?
Well, the definition of person in the Wang Family Trust is at page 385. And it's the same as in the GRT, and yet throughout that trust deed, as one might expect, purposes are dealt with separately and differently and called purposes. And then at clause 6 on page 392, which is equivalent to clause 11 in the GRT, the statutory powers are incorporated by reference, but they're to be read in the WFT, Wang Family Trust, on the basis that beneficiary should be read as purposes. Another distinction to be made with the GRT. So we say that you can't add a purpose to the GRT, and that which you can't do because it doesn't fall within the definition of person, and that which you can't do through the front door, you can't do through the back by adding the trustee of a purpose trust as a beneficiary because it is a person. And the additional indicia that we get to support that arrives out of clauses 3, 4, 9 and 19 of the GRT. Clause 3, the addition of trustees of another trust as a beneficiary of the GRT and a declaration under clause 3, for example, that the assets of the GRT are held for that trustee during the trust period, would, if that other trustee, that added trustee, had a discretion to exercise, as the Grand View does, would be a plain case of delegation, breaching the rule against delegation, that rule being explained by Mr. Justice McGarry in the Ray Hay case at page 4933 E to H. And clause 3 expects all beneficiaries to be able to benefit from an appointment under it, because it specifically refers to trusts in favour of all or one or more of the beneficiaries. So clause 3, we say, is not contemplating that one of the beneficiaries with a capital B was a trustee with a discretion. Clause 4, any transfer has to be to or for the benefit of a beneficiary, and as the Court of Appeal in this case correctly held in paragraph 269, page 250, Grand View, the beneficiary, does not benefit from the distribution that is made. It is the purposes which benefit. But clause 4 requires the transfer to be to or for the benefit of the beneficiary, and that's Grand View, not the purposes. And the case of X and A, page 5818, paragraph 45, is authority for the proposition that to or for the benefit of does not permit a payment to someone if it's not for their benefit, because that would be a classic fraud on the power.
Could I have the page number again, please?
Of course, my lord. It's X and A is 5818, and it's paragraph 45.
Thank you.
And it makes the point that the to and for the benefit of are effectively inextricably linked. Clause 9, adding a trustee as a beneficiary in order to make a distribution for the benefit of the trust of which they are the trustee would sidestep the proviso in clause 9, and that cannot have been intended, we say. You'll hear more about that from Mr. Hagan in just a moment. And clause 19 is the clause relating to the marital property regimes, which provides that any benefit devolving on a beneficiary shall be and remain the sole, separate and exclusive property of such beneficiary, and we say that could never apply to the trustee of another trust. And so we say that putting all that together and looking at it in the round, the GRT did not contemplate a trustee of another trust, and certainly a trustee of a purpose trust, being added as a beneficiary at all. Now, that doesn't mean that the GRT could never benefit another trust or a charity, because it can make a transfer to another trust of which one of the beneficiaries is a beneficiary under clause 9, provided that the vesting proviso, the remoteness of vesting proviso, is complied with. And if it was, if they wanted to make a distribution to another trust of which a family member was a beneficiary, but that family member wasn't a beneficiary of the GRT, and it was appropriate to do so in the exercise of its discretionary power, it could simply add that family beneficiary as a beneficiary and then make the distribution to the trust in question, because that beneficiary would be a beneficiary under it, and that's permitted by clause 9. Distributions to charity can be made where they amount to a benefit to a beneficiary under a trust. So where a distribution, for example, fulfills a moral obligation of the beneficiary.
Sorry, they could make, so if they wanted to distribute a family member who was not a beneficiary with a capital B,
yes,
they could add the family member as a capital B beneficiary and then transfer to a trust of which they were a beneficiary, but they don't need to add the trust as a person.
exactly. Exactly so. And they have to comply with Clause 9. But that then makes it all work. And then distributions to charity, there is clear law that, and Ray Claw's settlement is probably the classic statement of this, which is at page 4842, or particularly 4842 and 4843 is the head note, I think, which is authority for the proposition that a trustee who does not have a charity as a beneficiary can make a distribution to a charity if the distribution is in fulfilment of a moral obligation of one of his beneficiaries. So the charity does not need to be added as a beneficiary in order for that distribution to be made, because it benefits the beneficiary who is already an object of the power of disposition. Now, we say also that the same result as I've been submitting to your lordships and your ladyship can be achieved via the implication of a term if necessary.
Can I just interrupt? You started this submission, I think, as a matter of construction of Clause 8, and that the word person did not include a trustee.
Yes.
Is that right?
Yes.
So will you be addressing Clause 1.6, the definition of person?
So, yes, so Clause 1.6...
Because that specifically includes any person acting in a fiduciary capacity.
Yes, but subject to wherever the context permits.
So you say that person in Clause 8 doesn't include a person acting in a fiduciary capacity because the context otherwise requires.
That's right. And I say it doesn't include a trustee of another trust.
Even if it's a charitable trust?
Yes.
Yes.
I do.
What about a... Yes, I see. Doesn't include any trustee. Yes, I see.
So I say that the context, when looked at as a whole, the indicia that I've given, doesn't allow person to mean a trustee for the purposes of Clause 8. And therefore, under Clause 8, a trustee of another trust can't be added as a beneficiary with a capital B.
I thought you were confining that proposition to where you had a trust for purposes, whether charitable or non-charitable. I mean, if it was a trustee acting for under a trust for people,
Yes.
then you wouldn't have the same objection, presumably.
Then you wouldn't need to add the trustee as a beneficiary, and it's most odd to do so.
I see.
Because if you've got a trust, another trust for Winston Wong, for example,
Yep.
then the trustees of the GRT can make a distribution to that settlement, even though there are other people under that settlement who will also benefit, if they take the view that that transfer or that distribution is for the benefit of Winston Wong. So you never have to, and it's most peculiar to, we would submit, add the trustee of another trust as a beneficiary, i.e. the object of a power of distribution. So the same result, we say, can be achieved by the implication of a term, and Mr. Justice Warren goes through all of that in PNPF. And in Equitable Life and Hyman, Lord Steyne decided the case on the basis of an implied term, although Lord Cook said the same conclusion could be reached by an application of the proper purpose doctrine. So, and that's Equitable Life is particularly at page 3823. That's Lord Cook saying the same conclusion can be reached from starting from the principle that no legal discretion, however widely worded, can be exercised for the purposes contrary to those of the instrument in which it is conferred.
And this is an implied term, a legally implied term, or an implied term on a sort of business efficacy sort of officious bystander test, or the contractual term test?
It's plainly intended. So I can't remember which of the case it is that says, and I think it's PNPF actually, that it's by reference to something that Lord Hoffman had said, that applying all sorts of different sort of words to a test which essentially is saying the same thing isn't necessarily terribly helpful. What you're looking at is what the economic settlors in this case actually intended these powers to be used for. And you can do that simply by way of construction, and you can do that by saying, well, I'm going to imply a term. And you can do that separately by saying that actually there's an equitable doctrine that they're only to be used for the purposes for which they're conferred, which constrains them. 3 different ways that Mr. Justice Warren goes through in PNP. And as he said in that case, Mr. Justice Warren, and that's at page 4649, by reference to what Lord Hoffman had said in the Belize case, the implication of a term is not an addition to the instrument, it only spells out what the instrument means.
So what is the implied term we're talking about here?
The implied term is that the power to add can only be used for the purpose for which it was conferred.
I'm sorry.
And can't,
right, we've gone away from person and so
yes,
on.
my lord, I'm sorry.
Yes, sorry, right.
And cannot be used to destroy the substratum of the
Yes,
trust.
sorry. Yes.
Yes, where Mr. Justice Warren in PNPF speaks about implied terms, he's of course looking at the Belize case, which was later qualified, I think, by this court in Marks and Spencer.
Lord, yes.
So his reasoning would have to be assessed as against the Marks and Spencer criteria.
I accept that, my lord. But our primary position is that for the reasons that we respectfully submit and are more fully set out in our written case, the Court of Appeal was wrong to hold that the GRT trustee's use of its powers to give its entire trust fund to the Wang Family Trust was permissible.
So just so I understand your answer to my lady's question, I think you're saying that it's a term implied in fact because it's plainly intended, was your phraseology. So not implied in law, implied in fact in the circumstances of a particular case.
Lord, yes.
Okay.
We say that what was done was impermissible, as Acting Justice Kawley held. But unless I can assist your lordships and your ladyship any further on that first point, I'll hand over to Mr. Hagan for the second point.
Thank you very much. Yes.
My lords, my lady, this issue, the next issue, arises out of the fact that the GRT contains a prohibition on transfers to other trusts, as was the case in this case, when those transfers would or might infringe any applicable rule governing remoteness of vesting. And your lordships and your ladyship should have Clause 9 straddling pages 370 and 371 of the bundle. And this aspect of the case raises 4 questions for the board to answer. The first one is, what does the word might in might infringe relate to in the Clause 9 prohibition? The appellants say it was intended to prohibit resettlements of GRT assets in a manner potentially prospectively invalid under the rules against remoteness of vesting, modified by the wait and see rule. And the respondent essentially says that the word might in Clause 9 does not do that. The second question is, was the Clause 9 prohibition intended to capture all resettlements of GRT trust property on other settlements? The appellants say yes, the respondents say no. There were 2 ways, they say, of affecting resettlements of GRT trust property, and Clause 9 and its prohibition only caught one of those types. The third question is, on the facts of this case, was the transfer from the GRT to the WFT one which might infringe any applicable rule governing remoteness of vesting? The appellants say yes, the respondents say no. And the fourth question is, if so, should the GRT trustee be taken to have implicitly deleted by amendment under Clause 10 the prohibition at the end of Clause 9 so as to validate the transfer to the WFT? The respondent says yes, and we very much say no. So the first question is, what does might infringe in Clause 9 mean? So we're not at this stage looking at what types of resettlements Clause 9 and its prohibition or attempt to cover. We are just asking what might infringe in that clause means. The appellant's case is that the prohibition was obviously intended to do something when it used the word might as well as would. And the obvious candidate for what that word was trying to do in Clause 9 was capture those dispositions which were prospectively invalid under the wait-and-see rule, not just those which would definitely be invalid. And if that construction isn't placed upon the prohibition at the foot of Clause 9, then it's not doing anything at all. And in fact, this point is underscored by two observations, which for reasons of time I won't spend too much time delving into, but I'll just state what they are. The first is that the word might is one which immediately tracks itself or captures the notice of a lawyer familiar with the rule against perpetuities, because it's the very word that's used in the statutory regime which creates wait and see. So that's the 1964 legislation in England, or in Bermuda 1989. So, and the reference for your note is page 1953, which contains the relevant part of the statute. It's section 5 of the 1989 Act. The second point is that the language of Clause 9 is a manifest adaptation of standard form language from that schedule of provisions that Mrs. Talbot Rice took the board to, which you can incorporate as a settlor into your trust by reference in Bermuda. So it's a schedule of provisions at the end of the 1989 Act, and you can just say, I want those in my trust. That schedule of provisions contains something very similar to Clause 9 of this trust instrument. But interestingly, the words might infringe don't appear in it. And for your note, it's page 1974. And that sets out the provision from the schedule. And if one looks at 3A on that page, one can see a...
So this is a sort of model clause together.
Exactly. And the draftsman of Clause 9 in this trust instrument took that model clause and quite deliberately changed the proviso at the end of it to include the word might, which immediately sends one mentally to the language of the wait-and-see rule in the statute. So it's quite clear, I say, that unless the proviso at the foot of Clause 9 was to do literally nothing, that it was aimed at capturing transactions which were in violation of the rule against remoteness of vesting, even when they would be saved pro tem by the wait-and-see rule. Now, why, might one ask, would that be a good idea? Because generally speaking, I accept this, the wait-and-see rule is a salutary thing which saves gifts. But one of the disadvantages of it is in the specific context of trust-to-trust transfers. And the reason for that is that the perpetuity period of the disponing trust, the transferring trust, governs the period within which interests in the transferred property must vest, irrespective of the perpetuity period of the transferee trust. So if you are a trustee and you resettle your trust assets on another trust, which in some jurisdictions aren't required to have perpetuity periods, ironically, Bermuda today doesn't require you to have perpetuity periods, but at the time it did. then you will never know whether in however many years' time, when the perpetuity period of the transferring trust comes to an end, whether or not the assets will come careering back. My learned friend, Mrs. Talbot Rice, used the metaphor of a boomerang, and that's quite a good way to think about it. And that can create chaos. I mean, take this case, for example, where the trust was purportedly wound up. In 100 years' time, the assets come shooting back, and it comes back to life. The trustee's been dissolved. The beneficiaries don't know that it exists. Who is the trustee? One can well see why a settlor might say, look, you can transfer assets to other trusts, but you've got to be sure that the transfer will stand the test of time. And if it won't stand the test of time, that's a transaction you mustn't enter into. And you've got to be sure of that. So that's the policy behind it. And I asked the board to bear that policy in mind when considering the second question. The second question is, was the Clause 9 prohibition intended to capture all resettlements of GRT trust property to other settlements? So we have a situation where there is a policy in this trust instrument that it's a bad idea to have transactions to other trusts which might boomerang back in 100 years' time. And so the question is, surely, I ask rhetorically, it must have been the intention of the settlors of the GRT that they would not want to create an arrangement where some such transfers may be potentially invalid and others wouldn't be. Now, the reason why this is germane in this case is because the respondents, and I must accept the Court of Appeal, read Clause 9 in a very restrictive way. They read it accordingly, essentially as follows. That Clause 9 only applies, and therefore by definition its proviso only applies, if A, the trust fund is transferred to someone not already a beneficiary of the GRT, qua trustee, and B, the other settlement to the trustee of which the transfer is made is for the benefit of a beneficiary of the GRT. So what they are essentially saying is that if you choose to add the trustee of the trust to which the resettlement, on which the resettlement is being made as a capital B beneficiary and transfer the assets to it under Clause 4, you can get round the Clause 9 prohibition. Now, 2 points arise from that. The first is, let's suppose they're right. That is very clear context if they are right. To go back to those words that my Lord David Richards mentioned earlier, where the context requires. That is very clear context why it must be right that person in Clause 1.6, as it is used in Clause 8, was not intended to include the trustee of another trust. That way, there was but one funnel through which all resettlements could take place, Clause 9, and all resettlements would be caught by the prohibition at the end of Clause 9. So that is clear context, and Mrs. Talbot Rice has pointed to other points of context, but that's a really good one in my submission. Let's suppose that's wrong. Let's suppose that my learned friends on the other side of this courtroom are right. And let's suppose that it's correct that there was a loophole, or at least a purported loophole. So every time you wanted to resettle assets from the GRT on another settlement, you could choose either to go through the Clause 9 route, or you could add as a beneficiary the trustee of the transferee trust and transfer the assets absolutely to it. And the reason, and I should point out that I'm not just talking about the peculiar transaction in this case. My submission is that when one thinks about it, that could happen in every single instance of a resettlement. I mean, let's suppose that one was proposing to resettle assets from the GRT on a trust under which Susan Wang was a beneficiary, but it would be caught by the Clause 9 prohibition. My learned friends say you just add the trustee of Susan Wang's trust as a beneficiary under Clause 8, and then you transfer the assets under Clause 4. Now, if we're in that world, I say it's a perverse construction of this trust instrument that the Clause 9 prohibition shouldn't capture all forms of resettlements, because it would make the Clause 9 prohibition nugatory, avoidable in every single case, and essentially pointless. And just to fast forward in my submissions to another point, if my learned friends are right about Davis and Richards and Wallington Industries, the Clause 9 prohibition would definitely be avoidable in every case, because the trustees would always be taken implicitly to have used the route which validated the transaction. It just cannot be right that the Clause 9 prohibition is not applicable to every mode of resettlement which is selectable. And if there's any unnaturalness in the language in Clause 9, there is at least enough there to enable this board, if the board is not with us, and the board finds that there were two modes of resettlement available under this trust instrument, there is enough in the language to find that the prohibition must have been intended to capture all resettlements. And learned friends focus on the words such. They say that if one looks at the end of Clause 9, where it says no such prohibition, that's on page 371.
No such payment.
No such payment, I apologise. No such payment or transfer. The payment or transfer being referred to must be the precise one that's being described in the earlier part of the section. And they say that the natural reading of the language of the earlier part of the section is that it's not intended to refer to a transaction where the trustee and the beneficiary with a capital B are the same person. But as I say, because that would lead to such a perverse result, some flexibility in the construction is required here to avoid perversity, essentially. The word such in the English language can sometimes be language of exemplification, as well as language of specificity. If I were to say no such person, or a person such as that, I'm using the word such as a form of exemplification, not specificity. If I were to say X is a criminal, no such person should join the police, I'm really saying that people like X shouldn't be allowed to join the police. I'm not saying X in particular. So the word such can have different meanings. And as I say, there's enough there in the language for this flexible approach to be adopted, which I pose, albeit underscoring the fact that our primary case is that, and the simplest answer to all of this is for the board to find that it was just simply impossible to add a trustee of another settlement as a beneficiary under Clause 8, and then the whole thing works. So on that footing...
So just to ensure I understand this, the boomerang that you're referring to, it would arise if there was a transfer to a trust and the terms of that trust were not limited to an appropriate perpetuity period. The wait-and-see rule would ordinarily apply, so you just wait and see whether everything vests within the period of that the receiving trust. But you say, well, what if you wait and see and it doesn't vest? Then it would have to come back to this trust because it would turn out to have been a void.
That's correct.
Transfer.
It's potentially prospectively invalid.
Yes. And then the money would have to come back.
And it would have to come back.
To this trust, which then wouldn't exist anymore.
In 2101. The trustee having been dissolved. Because that's 100 years after the creation of the GRT. And so you can see the GRT settlor thinking, don't enter into transactions where that might happen, please. So the next question is if the board finds that there was the learned friends are right that it was possible for there to be a resettlement by adding a trustee as a beneficiary and transferring the assets to it under Clause 4. But I am right on my alternative case that that is caught by the prohibition at the foot of Clause 9. The next question is on the facts of this case, was the transfer from the GRT to the WFT one which might infringe an applicable rule against remoteness of vesting? Now, in short, I've got 3 points on this. The first is this. Even taking the respondent's position on the law at its highest, which is to the effect that the relevant law governing vesting of interests under charitable purpose trusts and non-charitable purpose trusts, save in one aspect, which is the rule in Christ's Hospital, which I'll explain later, is the same, and we dispute that case. The transfer of the grid shares to the WFT in this case was still subject, I say, to a condition amounting to a contingency for the purposes of the rule against remoteness of vesting, and therefore it was potentially perpetuitous, even applying the wait-and-see rule. My second point is that, in fact, that's the wrong approach for remoteness of vesting, so we have a legal dispute between us. I say that even if you apply my first point, the facts to the respondent's version of the law, we still win. But my second point is that, in fact, the approach to the vesting of interests in charitable trusts has no application in the context of non-charitable purpose trusts, because non-charitable purpose trusts are a species of private trusts, and one applies the usual rules in relation to vesting to non-charitable purpose trusts as one would to private trusts. And my third point is that even if that is wrong, the interests of the purposes under the WFT was still subject to a relevant contingency, because the WFT was a trust for a suite of different purposes, and the trustees had to choose to which of them to apply the property represented by grid shares in this case, and that was a potential violation of the rules against remoteness of vesting. So those are the three headline points. And to take the first of them, in essence, the respondent says that there is a perfect concurrence, save in one limited respect, as respects vesting of interests in charitable trusts on the one hand and non-charitable purpose trusts on the other. They essentially say this, that once the property is devoted to charitable purposes per se, it vests immediately. And questions of timing or selection between different purposes or whatever thereafter are all just questions of mode of implementation. And in a charitable context, those aren't contingencies which amount to violations of the rule against remoteness of vesting. However, they accept that if the property itself is only conditionally devoted to charity, then that is a contingency which, which could lead to invalidity under the rule against remoteness of vesting. So a useful case in this regard, because it's very recent and it goes through lots of the authorities in the bundle on this topic, is Attorney General and Zedra. This is the fascinating case which you might have seen in the press about the National Fund, which someone called Gaspar Farah set up to pay off the national debt in the 1920s. And there was an issue as to whether or not it was charitable. There were proceedings in the Chancery Division brought by the Attorney General against the trustees and various family members. Now, it wasn't strictly speaking a perpetuities case, because it was being said that the devotion to charity of the fund was conditional, and the condition simply had never been met. But all of the cases on vesting and perpetuities were looked at, or the main ones were, by the court. It's in the bundle at page 3031. If one looks at, for example, page 3087,
Did you say 3087?
887, my lord, yes.
3087?
No, that's
No,
not right.
that's,
Oh, I do apologise.
that's our Northern Britain.
That is a typographical error. It's paragraph 27 of the judgment, which is on page 3037. One sees the gift there described. Trustees shall hold the national fund upon trust until the date of application to accumulate the net income, etc., etc. And I'm not going to spend time reading it out because I'm conscious that my learned friend Mr. Wilson needs to get on. But the central point was this, that the fund did not need to be used for the purpose of paying off the national debt until a particular time in the future called the date of application. And so it was said by family members, descendants of Gaspar Farrer, that therefore this was a conditional gift and that the timing issue created conditionality. That argument failed, and the reason for its failure can be discerned first by looking at the submission of Mr. Henderson for the Attorney General on page 3044, paragraph 66. In support of his submission that the deed effected an immediate and unconditional gift of the national fund to the trustees, Mr. Henderson submitted that the deed provided comprehensively, and I place reliance on these words, for all capital and income to be applied for this stated purpose with no alternatives, conditional or otherwise provided for. And then if one looks over the page to page 3045, one sees reference to many of the authorities which are cited in the learned friend's skeleton argument, Chamberlain and Brockett, paragraph 71. There's a statement of principle which is worth looking at. The question was whether, upon the true construction of the will, a trust for charitable purposes of the whole, and I placed reliance on that word, residuary personal estate was constituted immediately upon the death of the testatrix, or whether the charitable trust as to residue not required to make the fixed payments mentioned before the directions as to the almshouses and almspeople was conditional upon the gift of land at an indefinite future time for the erection of almshouses. And then over the page, there's another quotation from Lord Selborne in paragraph 74, page 3046, where it was found that the intention in favour of charity is absolute, the gift and constitution of the trust is immediate. And there are some examples on the next page, 3047, of when gifts were not immediate. So in 79, there's the Lord Stratheden case, which was where the gift was suspended until the appointment of a lieutenant colonel of a regiment, which no one quite knew when that was going to happen. And in Manda at 80, the question was, the gift was suspended until someone came forward to become a priest, and that was also regarded as a condition which might only be fulfilled at too remote a time. So the question, and at the end of it all, the judge found at 81 that since the question in each case is dependent on true construction of the relevant trust instrument, limited, if any assistance is gained from a comparison with conclusions reached by judges on the facts of other cases, the critical question is on the meaning of the words in the deed. Now, as I've said, I don't actually think that much support can be gained in this case from analogies with charity. But this is one issue in respect of which the law of charitable purpose trusts and all other trusts have something in common. If the gift is conditional on an event which might arise at too late a time, then the rule is violated. And the question is whether the entirety of the fund is devoted to the purposes. So let's have a look at page 381 of the bundle. and in particular, which is the Wang Family Trust instrument, and in particular at page 388, under clause 4.1, this is the gift. The trustees shall hold and invest the trust fund upon trust to pay or apply the whole or any part thereof in fulfillment of the purposes and the founder's vision in accordance with the guidelines set forth below. So pausing there, it's 2005, the trustees of the Wang Family Trust received the grid shares. It's the 8th company that which they've received. They received 7 in 2001 and grid in 2005. Their obligation is to pay or apply the whole or any part of the trust property to the purposes. They have no obligation to devote the entirety of their trust fund to the purposes. In the National Fund case, there was an obligation to devote the entirety of the fund to the object, but there was a timing issue which was internal to the gift. Here, there is no obligation to apply the whole of the fund to the purposes. So the grid shares might have been applied to the purposes, or they might not have been. And you can wait forever under this trust and still not know whether the grid shares would be applied to the purposes. So it was, even by the likes of the charities authorities, a conditional gift. And fortification for that arises in paragraph 4.1.1. The trustees shall invest all or a substantial portion of the trust fund in shares of stock of the Formosa Group, as the trustees, using their best judgment, shall determine is sufficient to enable the trust to accomplish the purposes. Again, that suggests that they might have more than they need to accomplish the purposes. That is fortificatory language in connection with my construction of 4.1. So that is one point.
Right, but this trust itself would not be void because of remoteness of vesting.
No.
Because the wait and see
Because of the wait and see rule. That's correct. It's still valid today, subject to the claims in the other action which aren't before the board. But what you have is...
So there is a perpetuity period applicable to this trust, is there?
It would be implied by statute as being lives in being plus 21 years.
So it's not, in that sense, it's not like a charitable trust.
Well, charitable trusts are subject to the rule against perpetuities, but they do not need to have but they're not subject to the rule against excessive duration.
Yes.
So, but it's only because of the special rules in relation to vesting, which is what I'm going to come on to now. The scope of the rule against perpetuities is very limited in application.
So you can just wait and see whether, in fact, the whole of it is within lives in being plus 21 years devoted to the purpose.
Yes. If the analogy with charities works. I mean, for example, above 3, I should probably point out, it said that this trust is established for the following purposes. But my point is that the gift is in 4.1, and the gift does not require all of the property to be applied for the purposes. But even if I'm wrong about that, there are 2 other reasons why this trust violates the rule against perpetuities. The first is that I do dispute the heavy reliance placed by the respondents on the proposition that one just copies and pastes across the rules in relation to charities, with the exception of something called the rule in Christ's Hospital. And I said I'd explain what that was. That's the rule which enables gifts over from one charity to another, which the gift over arising at too late a time, not to violate the rule against perpetuities. And they say that doesn't apply to non-charitable purpose trusts, but that's the only difference. I say that the charities points are largely a red herring. And the reason I say that is because non-charitable purpose trusts are essentially private trusts. I mean, they can exist at common law in certain circumstances. You don't need the statute in Bermuda for them to exist. It's important, though, to distinguish between two different types of non-charitable purpose trust, and a lot of confusion arises from the fact that one doesn't make this distinction. The first type are those which are wholly abstract and wholly impersonal, and they're often called trusts of imperfect obligation or the anomalous cases. Where Homer has nodded, I think one judge described them as being. And these are the cases which I think someone else said were close to the bosom of Englishmen. So trusts for dogs and horses, fox hunting, I think was one. Tombs and monuments seem to come up quite a lot. So now in respect of those trusts, there is no interest which is capable of vesting within a perpetuity period. So the common law rules in the rule against remoteness of vesting simply couldn't be applied to them. And although I don't have time, I'm conscious of the time, it's worth looking at Philip Jameson's explanation. This is an academic article written in 1985, Trusts for the Maintenance of Particular Animals. And that's in the bundle under tab 21, page 7678. But because the rule against remoteness of vesting couldn't apply to those funny, anomalous cases, a separate rule of excessive duration was developed to prevent the policy of the rule against perpetuities being violated. So that's why there's a rule against excessive duration. But it also strongly suggests that you don't have immediate vesting in these non-charitable purpose trusts. The point is, insofar as they're wholly abstract and wholly impersonal, there's no scope for vesting at all. And that's why a separate rule was required. And that's why an analogy with charities doesn't quite work. Indeed, it's an interesting academic or legal question as to why it's said that in cases such as the charities cases that my learned friends rely on, there is immediate vesting when the fund is dedicated to charity. In one commentator, it's in the bundle Wolf under tab 252, page 8371, suggests that the legal theory is that the gift vests in those members of the public who benefit from charity. Who knows? It may not matter. But the fact is that one is dealing with two very different worlds here. Private trusts and charitable trusts, and non-charitable purpose trusts are a species of private trust. They are not a species of public trusts like charitable trusts. Again, just for the board's note, because I'm so conscious of the time, my learned friend's citation of the Kane case, which is in page 6817, the relevant passage, where it is said that the gift vests immediately in a non-charitable context. That is a case about an unincorporated association, so the gift vested in the members. It doesn't assist this board at all for the purposes of this case. And also, they refer to the cases of Latimer, which is at page 4337, and London Hospital, as cases which suggest that, that in charities, you don't look to those persons who will benefit from the charitable gift as beneficiaries. They are mere incidental objects, as it were, of the gift to the charitable purpose. Well, that's all very interesting, but neither of those two cases is about a non-charitable purpose trust. Neither of them is about the rule against remoteness of vesting. The London Hospital case is at page 4419. And in fact, we know that non-charitable purpose trusts operate very differently, because I began by identifying that strange category of impersonal and abstract non-charitable purpose trusts. But in fact, probably the majority of non-charitable purpose trusts are neither impersonal nor abstract. They're just trusts which benefit persons, which are framed as being for purposes. The most famous example of that is the decision in Denley. That is the decision which which is at page 4874 under tab 120, where it was held that a sports field for employees was not invalid for violation of the beneficiary principle, even though the trust was framed as a purpose trust, maintaining a sports field being a purpose, because the employees were akin to beneficiaries and satisfied the beneficiary principle. And the existence of a case like Denley shows that we're in a completely different world with non-charitable purpose trusts and charitable trusts. So in that context, how does the rule against remoteness of vesting work when you have a trust which will benefit persons, or could benefit persons, but which is framed as a non-charitable purpose trust? And the answer to that is exactly the same way as it would work in a normal private trust. Why is that, I ask rhetorically? Because if that isn't the law, then the rules against perpetuities could always be avoided in relation to private trusts for persons by simply framing them as trusts for purposes, but which benefit persons. So it's completely coherent to expect the law in relation to non-charitable purpose trusts which can benefit persons as working from a perpetuities perspective in exactly the same way as those which are normal private trusts with named beneficiaries. And my authority for this is the Compton case, which is in the bundle at page 4848. Under tab 118. Now, the Compton case was was a case about a trust which failed as a charitable trust. So it was a scholarships trust for the descendants of a particular family, which was not time limited. And the matter went to the Court of Appeal and it was found not to be charitable. So it was said that it was a charitable purpose trust, but it wasn't, so it came back down to the High Court for the High Court to decide whether or not it had failed for perpetuity. If the board looks, please, at page 4850, you will see that the trust was actually described as for purposes at page 4850F. So it's being understood as a non-charitable purpose trust. And then the question is, and then at G on the same page, Mr. Justice Romer says, that it seems reasonably plain that the idea or conception which the testatrix had in mind was to set up for an indefinite period a trust to benefit in a specific way, that's the purpose, the lawful descendants of those three respective persons, those lawful descendants being described for the sake of brevity in the early part of the disposition as children. If the effect of the gift is that the trustees are to hold this fund in that way, it would appear at first sight that the rule against perpetuity is infringed under certain rules which are well known and which are referred to in Jarman on Wills. Now, the edition of Jarman on Wills that he was referring to there was the 1930 edition, and the pages that he cites, 278, 279 and 304, which are in the bundle at pages 7682 to 5, concern the normal rules against remoteness of vesting.
Which
they are
pages?
dated.
Sorry,
7682 to 7685. In other words, there is no suggestion that the gift has vested immediately in the purpose. You just ask yourself the question whether there are future interests which are too remote or which might vest at too remote a time. You just treat it like any other private trust. Over the page, from D to H onwards, he considers whether it's possible to save the gift by construing it as being limited to a time period, but he finds he can't. And as I say, it makes perfect sense. It can't be right that you can just sidestep the normal common law rules against remoteness of vesting by framing your trust for beneficiaries as being for a specific purpose. The law makes sense.
So it failed then, did it? The gift?
Yes, it failed in Compton.
So you said over the page at letters,
Oh, D to H, I think I said.
D to H, that's in the judgment of Mr. Justice Moore.
No, he's quoting it. He's referring to a judgment of Mr. Justice Mormon Hooper.
Oh, I see.
Still the judgment of the.
Oh, yes, I see that.
Chardon in Compton.
Thank you very much.
So, if I'm right about this, then the question is, were there future interests which might vest within the WFT at too remote a time? And if one looks at the WFT again at page 387, one sees that there were a suite of purposes on page 387. And then if one goes over the page to 388, one has the gift that I referred to earlier, which must be coupled with a power, otherwise it doesn't make much sense to pay or apply the whole or any part thereof of the property to the purposes. And what you really have, and who are the purposes for? The purposes are for FPG and various named institutions which are said to be charitable. For example, one of the purposes is ensuring FPG's competitive edge, to ensure that the Formosa group of companies maintain their long-term global competitive edge. So one can identify persons within this trust who are intended to benefit, rather like the proposed recipients of scholarships in Compton. And why shouldn't you just treat this like any other discretionary trust for the purposes of remoteness of vesting?
Where was that bit about keeping its competitive edge?
Clause 3.2 on page 387.
So this was the purposes, some of them were charitable and some of them were non-charitable.
They're said to be, they're for institutions which are said to be charitable, and I don't think that's in dispute on this appeal. So there are some charitable objects, specific objects, and there are some which clearly involve private interests, such as FPG. I mean, I should say that in separate proceedings, it's being said that this trust is void for uncertainty, but that's not before the board today. So, given that the interests of these persons, the institutions, the FPG companies, such as they are, might vest at too remote a time, having regard to the perpetuity period of the GRT, it was a perpetuitous disposition. So that's the second reason, and no doubt that's going to be disputed, but even if I'm wrong about that, there's a third reason why this doesn't work. And the third reason is that even if we suppose that it is possible somehow it's possible for an interest in property to be carried by a purpose. So for the purposes to be the things which are the interests under this trust, let's just imagine that, however theoretically strange that is the law. It cannot be right that property vests immediately on receipt by the trustee of the WFT in circumstances where the trustee of the WFT has the power to select between 5 purposes. So even if one is to treat a purpose as an interest in which property can vest fictionally somehow, if there's a power, if you've got 5 purposes, or however many there are, a suite of purposes, it cannot be right that it is merely mode of application, to use the terminology of the charities cases, and therefore it doesn't amount to a contingency for the purposes of the rule against remoteness of vesting, that you have a power to select between them. Now, the reason why in charities cases mode of application is not regarded as a fatal contingency, is because one is dealing with this supervening, overriding concept of charity. But non-charitable purposes aren't manifestations of some wider whole. Non-charitable purposes can be highly contradictory and potentially unlimited. They can be commercial, they can be capricious, they can be many different things. Dogs, animals, multinational companies, anti-vivisection. There are all sorts of different things. And if you stuck 10 non-charitable purposes in a trust instrument, all of which are very different from each other, and gave the trustees power to select between them without appropriating the trust property amongst all 5, why wouldn't that power of selection operate no differently for the purposes of the rule against remoteness of vesting than a power of selection in a normal discretionary trust for persons? There isn't any authority on that about non-charitable purpose trusts, and if the board is not with me on my first 2 points, then I submit that it's in itself and taken on its own is a good enough answer as to why there was no vesting. So this was a potentially perpetuitous disposition, and the only way that it can be saved, and I've got to take this very, very quickly now because I know that there is some anxiety to my right, is if my learned friends can persuade you that somehow, when the disposition took place, implicitly, Clause 9 was amended such that the word might was deleted. Now, there was a power of amendment in the trust instrument at Clause 10. It could only be exercised by deed. You might think that if a settlor says you can only exercise this power by deed, he is intending to mean, therefore, you've got to take it very seriously and think about it. So it's a rather tricky starting point for the case that the court, or indeed this board, should be imputing an intention to the GRT trustee to have exercised a power which was only exercisable by deed to do something which they never intended to do, namely amend the trust instrument, by virtue of exercising a power which they never intended to exercise. It is a fiction upon a fiction. Now, I don't take a formalities point in relation to the question of the deed, because that has been held to be a tribal issue and there is no appeal on that question owing to the peculiar definition of deed in the trust instrument. But what I do say is that this board should not find that there is any scope for imputing an intention of the nature contended for by my learned friends in this case. My overarching point is that we must conform the so-called Davis and Richard and Wallington Industries line of authority to the modern law of fiduciary obligations. And I have 4 subsidiary points, which I'm going to take very quickly and which are, relatively speaking, short. The first is that in a case such as this, perhaps not in every case, but in a case such as this, imputing an intention to a fiduciary, a fortiori a trustee, to do something which the trustee never contemplated doing is at odds with the Turner line of authority. The second point is that what my learned friends call the Gleed exception must be taken to its logical conclusions, which includes Turner. The third point is that the Privy Council should follow Kane and Hutton in the New Zealand Supreme Court. And my fourth point is that the authoritative basis for applying, in Davis, for applying principles of imputed intention to fiduciary powers is rather more slender than it appears. So the Turner point is very simple. And it is that it is settled law that when a fiduciary does not address his mind at all to the exercise of a discretion under a power, that is a nullity. Now, what my learned friends do skillfully is to seize on the facts of Turner and point out how utterly extreme they were. The case involved a farmer who made a discretionary settlement which he did not understand and appointed as trustees family friends who never realised that they had any responsibility to save to do as he asked. They thought they'd be intruding into the settlor's affairs if they were to read the documents which they were asked to sign, and they basically didn't think about what they were doing. So the facts are very extreme, but the principle which Turner established, and we can find it in the bundle at page 2492, the principle which Turner established can be gleaned from just looking at the question which the judge asked himself at page 2487. It's C. The question is whether or not the trustees so far failed to direct their minds to the matter of their discretionary powers of appointment, that the deeds of appointment ought not to be regarded as an exercise of the powers of appointment.
Which letter is this in?
It's C to D,
C
my
to D.
lord.
Okay.
2487. So it's a question of whether they address their minds to the matter of their discretionary powers. And then if one travels to the end of the judgment at 2492C, if appointers fail altogether to exercise the duties of consideration, then there is no exercise of the power, and the purported appointment is a nullity. Now, that has been referred to without criticism by the Supreme Court in Pitt and Holt. So the point is this: how can there be a doctrine of imputing an intention to a fiduciary to have done something which he never did, under a power which he never contemplated, if he had purported to exercise that power but not addressed his mind to it, such that it was void? The two principles are at odds with each other if the Davis line of authority is taken to the extremities which my learned friends want to take it to in this case. And they will show you cases, they will show you LRT and HAT and other cases which has taken it quite far. But that's not what the law should be, and this board has an opportunity to correct it. They accept the so-called Gleeds exception. They accept that. They accept that there is an exception that where the exercise of the...
Glebe.
The Gleeds exception, yes, my lady, I'm sorry, I do apologise.
Yes, you mentioned it earlier. I know you're under time pressure, but
Just say what it
it'd be
is.
useful to know what
Yes,
it is.
I do apologise. So the Gleeds exception is the exception that the principle does not apply, the principle that you can impute an intention to a fiduciary to do something which he didn't contemplate if it's necessary to the transaction. The principle does not apply if the power in question would require the donee to have regard to materially different considerations where there is doubt as to whether the donee would have chosen to exercise that power had it taken different considerations into account. And that arises in the Gleeds case at page 3289 to 3290, paragraph 95A. So they accept that the principle is subject to a legal fetter, that when if the power in question would require the donee to have regard to materially different considerations, where there is doubt as to whether the donee would have chosen to exercise that power had it taken different considerations into account, then you can't impute an intention to exercise a fiduciary power, which hasn't been exercised. What I say very, very simply is that what I say very, very simply is that if the modern law of fiduciary obligations is to be applied properly to this doctrine, then why stop there? Because what the Gleeds exception is doing is accepting that there is a duty of adequate deliberation in respect of the exercise of a fiduciary power, and therefore that somehow needs to be conformed with the so-called Davis line of authority. But if you have to conform Pitt and Holt with the Davis line of authority, then you also need to conform Turner with the Davis line of authority. So that, and then I'm not going to go into this case because I'm very conscious of the time. But the third point, and I'm just going to invite the board to read the case, it's set out in our written materials, is the decision of the New Zealand Supreme Court in Kane and Hutton, which is at page 2548, particularly paragraph 35 at page 2564. That is the highest authority before this board which considers the implied exercise of powers. And I say that if that authority is followed by this board, then my case should be accepted on the topic. And the final point, very final point, is just to turn up the relevant passage of Davis itself, which I say should not be followed on the facts of this case. And that's in bundle 1 under tab 20. At page 2, the authority begins on page 2079. And if one travels forward to the relevant passage, it starts on page 2098 to 2099. So this is where the famous passage from Davis is upon which my learned friends rely. And I'm just going to show why it is that I say that the authoritative basis of this principle, so far as it's applied to the exercise of fiduciary powers, is rather slenderer than it might first seem. So if one looks at the top of 2098, the first case referred to is Cowlinshaw and Hardy, which you will find in your bundles if you want to look at it later, is at page 3632. That was a case about an implied exercise of a power of revocation, a quintessentially non-fiduciary power. Moggridge, I'll come back to in a second. Morgan, that you will find at page 4965. That was a case about a power, the exercise of a power reserved to a settlor, specifically called a reserved power at page 4965 of the bundle. That is a quintessentially non-fiduciary power. And then Wade and Paget at 2099, that case involved and you can find that case in the bundle at page 5713 or 8420. There are two reports of it. That case involved an exercise of a special power of appointment held by a successor to a life interest under a strict settlement of land. Again, I say, not a fiduciary power. So those are three of the four cases that were relied on. Only one of them, Moggridge and Clapp, involved a fiduciary power, and that was only because, and Moggridge and Clapp you will find at page 4534, Moggridge and Clapp was a case about an exercise by a tenant by courtesy of a sale of property under settled land, and by statute his power was deemed to be fiduciary. And that is the only case, I say, of those four cited which involved an exercise of a fiduciary power. So it's a slender basis to extend this principle to the exercise of fiduciary powers, and I say it should not be extended in the way that is put forward in this case. And subject to that, I rely in full on my written case, and I should probably conclude my submissions there. Thank you very much.
Conclude the game of musical chairs. I'll begin. As can be seen from the written case on behalf of Tony Wong, my lords, my lady, we agree with Mrs. Talbot-Rice and Mr. Hagan that the correct destination is one whereby the GRT's trustee actions in 2005 are invalid. But we submit, as you'll see from our written case, that the destination is reached by a slightly different route. In view of timing, I've been slightly squeezed, my lords, my lady. I'll do my best to rattle through it, but I'll largely give references rather than take you to the authorities as much as I can. And it may be that I may ask your indulgence tomorrow to take some more of our reply time to finish my principal submission.
You can certainly do that if it's agreed between the appellants, yes.
I'm obliged, my lord. So a point I'd like to make clear at the outset is that contrary to the suggestion made in the respondent's case, from Tony Wong's perspective, the case that is set out in his written case is not a secondary or fallback analysis. It's what we say is that it is the proper analysis of the position, applying what we say are orthodox and well-settled principles and concepts of trust law. And specifically, what we say perhaps is the most fundamental of all principles of trust law, namely that a trustee must exercise a fiduciary power for a proper purpose. In very broad terms, therefore, the issue between Tony Wong and the respondents is that, therefore, of whether the purpose of a trust and the powers conferred by it are to be exercised in the interests of the beneficiaries of the trust, or whether those powers are intended to provide a vehicle to give effect to the wishes of the settlor from time to time, because that is what we say the case is put forward by the respondent and found by the Court of Appeal essentially amount to. If I may, at this early stage, come back to a question that my lady asked Mrs. Talbot-Rice about the constraints on the exercise of a wide power conferred on the trustee. I think the example was given about the trustee deciding to give the trust property to a local takeaway. We accept, for the purposes of our analysis, the way in which it was put by the Court of Appeal at paragraph 168 of their judgment, which one finds at page 213 of that judgment of the bundle, where it summarises the law coming out of Pitt and Holt and sets out the three relevant questions. So, A, what we might call the excessive execution question. Has what has been done been something that is within the scope of the power? Secondly, the adequate deliberation question. Has the trustee carried out a proper process considering that which he ought to have considered and excluding from consideration that which he ought not? And then thirdly, the proper purpose question. And a difference between, I think, myself and my learned friend Mrs. Talbot-Rice is that we say one can view scope and purpose as separate issues. For the purpose of my analysis, I don't say that one has to construe down the clause in any way, read it down because of the purpose. On our analysis, any can mean any in the context of that clause. Any person can be added. The limiting factor, we say, is like any fiduciary power conferred on a trustee, it must be exercised for the benefit of the beneficiaries. Now, I will come to the question of what we mean by beneficiaries in this context. But the people it doesn't include, in terms of framing of the purpose of the trust, are the objects of a wide power to add. Because if we stop and think about it, that would include everybody in this room. Is it really to be suggested that the purpose of the trust, by reference to which the trustees exercise is to be judged would include the interests of anyone in this room. In my submission, that is nonsense. Now, the alternative to the interests of the beneficiaries, which seems to be offered as the touchstone for the exercise of this broad discretionary power by the respondent, is the wishes of the settlor, or settlors, or more accurate in this case, the founders. Now, we say, and I'll develop this submission in due course, that simply cannot be the answer for a number of reasons. Your Lordships and your Ladyship have been referred to the article by Professor Lionel Smith of Massively Discretionary Trusts, and because my learned friend's been to it, I don't need to take you to very much of it in the course of my submissions. But one of the points that he makes very forcefully in my submission is this, that if one has a trust that is that is for the purpose of carrying into effect the settlor's wishes from time to time, that does essentially collapse into a non-charitable purpose trust, because if the trustee's exercise of discretion is simply what the settlor wants, then it could, in principle, be anything. And one has to view it in those terms to see that that is, again, an absurdity. And it's also inconsistent, we say, with some of the very most basic, dare I say, day one principles of equity law that one learns about the respective relationships in a trust and the respective position of the various players or the actors in the trust. Starting with the settlor, we have that is the person making the disposition. That may sound basic, but it's important to note it, because his function, as we set out in our written case, is to make the gift. And the very purpose, in many cases, or in all cases of a trust, one would imagine, is for the settlor to dispose of his property.
Well, who is the settlor in this?
Well, we say the economic settlors are the founders, because they are the trust property which finds its way into the GRT is property which emanates from them. I'm afraid I can't be any clearer than my learned friend Mrs. Talbot Rice. And that's not a criticism of her. It's just that there are many factual issues that arise in relation to the ownership structure. But I think it's uncontroversial to say that they are the economic settlors.
The families, how defined?
I'm sorry?
How do you define the families in that context?
Oh, I don't define. I say YC and YT Wang.
Well,
the founders.
Well, it's just YC and YT.
YC and YT are the founders.
So you're agreed with Mrs. Talbot Rice on that?
Yes. Okay. Yes, I am. Because in the other proceedings, which are not before you, there is an issue about whether the arrangements that existed whereby Mr. Hung held the assets amounted to a nomineeship, or was a trust where he held it to their direction. It's not an issue that the board need trouble itself with.
Very strictly, isn't the GRT company the settlor?
Yes.
It's the settlor of the trust, in the sense that it declares the trusts, but the founders are the ones to whom the founders are the ones who are indirectly the settlors. They are the economic settlors,
well,
because their assets
they're the providers of the funds.
Yes, but they are.
But again, very strictly, I may be wrong about this. Very strictly, don't they provide the funds to the GRT company, and then it?
I think it's provided by Mr. Hung.
By Mr. Hung, yes.
On their behalf to the GRT company to hold on trust.
So where does the trust of the grid shares start with?
When it's transferred to the GRT to hold, the GRT trust company to hold on the trusts of the GRT.
Because the GRT company is the trustee.
Is the trustee of a trust. So if I give your lordship property,
okay,
I can say, there you are, my lord, that's yours. Or you could decide to settle it on trust yourself, or you could do whatever you liked with it. Or I could say, my lord, I'm handing you this property to hold on the trusts of the settlement that you have created already.
Okay.
And you would take as trustee, and the asset would become trust property as soon as I hand it to you in that way.
So again, just going back to when the trust started, doesn't it start, well, I rather understood Mrs. Talbot-Rice to say that actually the grid shares are transferred to Mr. Hung to hold effectively to be placed into the GRT trust. So maybe it doesn't matter. But doesn't on that analysis, the trust would seem to start from when the shares are put in the hands of Mr. Hung to hold on trust, to put them then into the GRT?
It may be best if I simply clarify that overnight and come back with an answer in the morning. If that.
I thought what happened was that the GRT company declares itself the trustee of the $100
Yes.
and is then the trustee of the $100 on the trust set out in the Declaration of Trust. But it then says anybody else who wants to put some money into this trust can do so, and we will then hold that money on the same trust as we're holding the $100. And somebody then puts, the founders then put in 600 million or
Yes.
90 million or whatever worth of shares, which they give somehow to the company, which then, as trustee, holds that on the same trust as it holds the $100.
That's my understanding. I will confirm it overnight, though, because I wouldn't want to misspeak now and waste time going around the houses in coming up with the wrong answer. But what your ladyship describes is the very common form of how a trust is declared and dealt with, particularly in the offshore world, that there will be a trustee company declares a trust over $10, $100. Sometimes there's a question about whether that money is ever paid to the trust, but because it's overtaken by the fact that much more valuable assets are then decanted into the trust.
It's a peppercorn, which...
Indeed, essentially.
Okay.
But what we say in this regard is that you have a set law that in a traditional model of a trust, the set law drops out of the picture when they have made their disposition. The crucial point that demonstrates that, we say, is of course that the set law does not have any rights to enforce the trust unless he's a beneficiary. If I settle property on trust for myself, of course I can enforce the trust, but because I'm a beneficiary, not because I'm a trustee.
Not because you're the settlor.
Sorry, not because I'm the settlor. Sorry, it's because I'm the beneficiary. And that is the key. And Mrs. Talbot-Rice has taken the board to the beneficiary principle, and I also rely on what is said in Armitage and Nurse about the irreducible core minimum, because Professor Smith describes the relationship between the trustee and the beneficiary as being the central axis of the trust. And it is because the beneficiaries are those for whom the property is held. Now, in a very traditional basic trust, if you want to call it that, it would be very straightforward. A holds property on trust for B, absolutely, and A is the legal owner, B is the beneficial owner. Now, of course, as modern trust law has developed, the vehicles that are used become more and more complicated, more flexible powers. We have the discretionary trust, so that rather than A holding for B, he holds for B, C, and D, or such of them as the trustee may choose. And that alters it. But it doesn't take away from the fact that the reason the obligations, the fiduciary obligations attaching to powers exist is because the trustee is holding property for somebody else, the beneficiaries. They don't exist in the air, fiduciary obligations. We are all, it's common ground that the Clause 8 power is a fiduciary power. It means it's subject to fiduciary obligations. And the question one has to ask is, to whom are those fiduciary obligations owed? Well, the answer is not the set law. He can't enforce the trust. The answer is the beneficiaries. And what is being suggested, though, that in exercising those fiduciary powers, in discharging the duties when exercising them of acting within the scope, considering relevant matters, and acting for a proper purpose, that the touchstone is not the interests of those beneficiaries to whom the fiduciary obligations are owed, but rather the wishes of the settlor from time to time. The person who supposedly has given up his property interest and should have dropped out of the picture. Now, I pause at this point to say that, of course, I am not saying, and it is no part of our case, that settlor's wishes are irrelevant to the exercise of a fiduciary discretion. I would have Supreme Court authority against me on that in the form of Pitt and Holt, and Lord Walker, I think, deals with that at paragraph 66. But we say that it is important, nay, vital, to distinguish between wishes being expressed with a view to assisting a trustee to fulfill the purpose of the trust, and wishes which purport to contradict or change the purpose of the trust on an ongoing basis. And so, as I say, our case is based on that simple, fundamental proposition that fiduciary powers, at least as a starting point, or a default position, and I'll explain my caveat in due course, is that those powers are to be exercised for the benefit of the beneficiaries. And my lords, my lady, I won't take you to this extensively at this point, but there are, in the bundles, we've put some extracts from Professor Finn's work on fiduciary obligations. I think it's been described by Lord Justice Millett as the classic, or I think it was the former Master of the Rolls, Lord Etherton, who described it as magisterial. May I invite you to read a number of paragraphs, and I'll take you to a couple now, if I may. Paragraph 44 at 2692, paragraph 74 at 2698, paragraphs 79 to 82 at 2700, paragraph 86 at 2701 to 2702, and then paragraphs 92 to 93 at page 2704. But for now, I just want to have a very quick look, if I may, at paragraph 82.
Just before you go there, can I just ask one question? Your proposition, as you just put it forward, or submission you just put forward,
Yes.
Is it tied in to the idea that you should only be looking at the settlor's wishes as at the time the trust is set up, as opposed to later on, or are you not making that bold proposition?
I'm going to do that classic thing, which I'm sure judges hate, which I'm going to say it depends. What I mean by that is that in terms of assessing the purpose of the trust, we say that must be set at the time the trust is established, because it is about the purpose of the disposition that is being made. The trusts are the terms on which that disposition is made. The role of a settlor's wishes on an ongoing basis may assist a trustee in deciding how best to fulfill that purpose. An example might assist. What I say is that if I set up a trust for my children, and clearly we say that the purpose of that trust is to provide financial benefits, financial security for my children. 5 years down the line, I, as a settlor, will know information about my children that my trustees won't. And I may have a child who's a spendthrift, may have a gambling problem, may follow the advice of putting it on the 230 at Toaster, as my lord said earlier. I might then say to the trustees, don't give this beneficiary capital, by all means pay for his education, put a roof over his head and give him a modest income. Because those are wishes that help fulfill the purpose of benefiting the beneficiaries. What I can't do in my submission is decide 5 years down the line, I don't like these beneficiaries anymore, get rid of them, let's have some new ones. And that, of course, is what happened in the context of the GRT. Because my example, I'm helping fulfill that purpose set at the beginning, which you assess and ascertain by reference to the terms of the trust and any other foundational documents, as we put it. But then the gift's made. The settlor can't change his mind unless he has a revocable trust and he keeps the power of revocation and decides to revoke the trust and say, well, forget that, I'll take it back and I'll put it onto another trust. The purpose is set. That purpose is ordinarily to benefit the interests of the beneficiaries, and any wishes subsequently, what the trustee has to do when considering those wishes, he has to assess the extent to which fulfilling those wishes serves or potentially contradicts the purpose. And so there is a duty established in Pitt and Holt to take into account a settlor's wishes. And I'll give the reference in due course, but there are a couple of New Zealand authorities, Kane and Hutton is one of them, which says that the trustee has to consider the wishes insofar as they are consistent with the purpose of the trust. So if we have that scenario where the settlor changes his mind and thinks, well, I don't like that group of beneficiaries anymore, sweep them away, that is the sort of situation in my submission where a trustee would have to say, I note the settlor's wishes, I've considered them, but I can't give effect to them because they contradict the fundamental purpose of the trust, which is to benefit the beneficial class.
Can I just check, does Lord Walker in Pitt and Holt draw this distinction that you've mentioned?
No, it's important to note that Pitt and Holt was an adequate deliberation case. The issue in Pitt and Holt was the so-called rule in re Hastings Bass, which was that a trustee could come to court and say, I am under a duty to consider those things which I am meant to consider, all relevant considerations. And trustees were going to court saying, actually, I haven't considered something. Can you set aside the exercise of my power because it's all rather inconvenient? And that was the issue about what the limits of that jurisdiction were. And the court held that that it's necessary to show that there is a breach of duty by the trustee in failing to consider that he should have considered. And as part of the wider discussion, Lord Walker commented on the fact that the settlor's wishes will always be a relevant consideration, but that, and my own friend Mr. Hagan referred to the Turner and Turner case, that if a trustee or other fiduciary simply slavishly follows the wishes of a settlor, then he doesn't exercise his discretion at all. So there is a balance to be struck. But it was never considered in the context of purpose. So that distinction didn't arise on the facts of Pitt and Holt and in relation to the issues that arose in that case. What I'll do overnight, if it's helpful, my lord, is I can highlight the particular paragraphs and give the references in the morning.
Well, I think you told us paragraph 66.
Yes, that's where the meat of it is on that issue. And so at page 2701, just very briefly to look at paragraph 82 of Finn, the way in which it is explained, if we see that the great complicating factor in review that a fiduciary taking his decision can properly be viewed from quite two different legal perspectives. At page 2700, first, he can be simply seen as the donee of limited powers, that is, of powers which themselves can only achieve certain purposes. Viewed in this way, judicial review is concerned solely with the efficacy of the purported exercise of power as a power. So that's really about the excessive execution point. One has to look at that. Its propriety being judged by reference to the nature and purpose of the power itself, Then he goes on to say the relevant judicial inquiry is, has the power been exercised for a purpose or with an intention beyond the scope of or not justified by the instrument creating the power? Secondly, and in addition, the fiduciary can be seen in the garb equity imposes on him, that is, as one who in the exercise of his powers is bound to act in what he believes to be his beneficiary's interests. Viewed in this way, a new dimension is added to the judicial review for the fiduciary obligation, interposes the interests of his beneficiaries as an additional screen against which the propriety of an exercise of power can be judged. The interests themselves ordain both the ultimate purposes for which he must exercise his powers and the overriding considerations which he must take into account in their exercise. And then paragraph 86, which I won't take you to in the interest of time.
But you adopt paragraph 82, do you?
Yes.
Because the second question is really the adequate deliberation question, isn't it?
Yes. I endorse it in that it covers all of the elements. I think the cleanest exposition of it now, bearing in mind that Professor Finn, I think, was writing quite a while ago.
Is it clear?
His work has stood the test of time very admirably.
Yeah.
That the way to look at it is, as one comes out of Pitt and Holt, and as is summarised at paragraph 168 of the Court of Appeal's judgment. But there are those three elements there. What Professor Finn...
Yeah, but what I mean, it's some of the submissions you've been making. You've been saying that the exercise of the power must fulfil, not contradict, the purpose of the trust.
Yes.
And it must be for the benefit of beneficiaries. Now, the latter of those, for the benefit of beneficiaries, seems really to marry with what Professor Finn says is the second and additional duty in that paragraph.
Well, my Lord, there is a question which your Lordships, I don't think, need to deal with, about the extent of the overlap between those second and third questions in Pitt and Holt about adequate deliberation.
Well, I agree. I think that may be, because I mean, for example, in Howard Smith and Ampol Petroleum, the issue of shares there was struck down on the basis that it was an exercise of a power for an improper purpose, because it was not proper to issue shares in order to change voting control, put shortly. But the second question, the directors may perfectly properly conclude that it is in the best interests of the company to alter the voting control and keep out a predator who's going to close down the business. But it fails on the first, which is the purpose. Now, it may be that the company analogy is not an exact one for the purposes of a case like this. Maybe you can't quite separate out the proper purpose of the power and the benefit of the beneficiaries in a way that, in a Howard Smith type of case, you can.
Well,
it's an area that is causing me a little concern, shall I say.
Our analysis in our written case, and I can take you to it in due course, distinguishes between what we say is if one likes, a power-specific purpose, as we phrase it, and a fundamental purpose. The former being, what is the power itself for? And the question of an investment power came up earlier in the course of questioning. The purpose of that, if one has a typical investment power allowing a trustee to invest in any sort of investment, is to allow a trustee to invest in any sort of investment, whatever it is. So unlike the old days when a trustee was not allowed to invest in equities and things like that, there is, we say, something beyond the four corners of the individual power, which we call a fundamental purpose, you might call it an overall purpose, of the trust as a whole, which we say is the interest of the beneficiaries. So it's not enough for a trustee to say, well, I've got a wide power of investment. The purpose of that is to allow me to invest in anything I like. That's it. I can go and, rather than doing something for the benefit of my beneficiaries, I can go and invest in my friend's ailing company, for example. There is this fundamental purpose because the trust has to be, we say, run for the benefit of its beneficiaries, because they are those to whom all of the fiduciary obligations are owed. The property that is being dealt with, to a greater or lesser extent, because we can talk about interests under a default trust or a discretionary trust. But ultimately, collectively, the beneficiaries are the owners of that property. It's theirs. And the purpose of the trust is the furtherance of their interest because it's their property that the trustee is managing. And so that's why we say that the purpose is used in two distinct senses in this context. The purpose of the power, as I think your Lordship has mentioned, and also the purpose of the trust as a whole, taking all of those provisions of the trust, saying, if I can put it crudely, stepping back and saying, well, what is this trust for? And it's for the beneficiaries. And when one considers the beneficiary principle, it should be fairly self-evident that it's for the benefit of the beneficiaries, because you need to have these beneficial owners in order to have a valid trust.
Yes, and I think the analogy with the companies in Eclairs and in Howard Smith is inexact, because part of the problem with those exercises of power was the upsetting the constitutional balance of who within the constitution of the company is supposed to decide whether a takeover will be accepted, and also the directors' own interests, even if they're acting entirely honestly, their own interests prompts them to believe that it's in the company's best interest for them to remain in the management rather than to be replaced by some incoming hostile shareholder. But I don't think those sorts of considerations really apply as between a trustee and the beneficiaries.
I think not exactly, no. But, I mean, paragraph 86 of Finn on 2701 may be of assistance on these issues. Because he says there that the ultimate end for which a fiduciary is given his powers is to serve the interests of his beneficiaries. And the ultimate issue raised when it's alleged that he's abused his powers as fiduciary is, has he in fact failed in some way to act in those interests? In a general way, it can be said that judicial review here is based on two inquiries. First, has the fiduciary intended to act in his beneficiary's interests, or has he acted for some other reason? And there's a quotation from Viscount Finlay in Hindle and John Cotton. And then it says, and if this inquiry discloses a variety of reasons for a particular action, the court must determine which was substantial or primary reason for the action. Secondly, and quite apart from the fiduciary's intentions in exercising a power, a decision may nonetheless be demonstrably not in the interests of his beneficiaries. Here, the courts have opened up another avenue for review. They're prepared to judge the propriety of a decision taken ostensibly in the beneficiary's interests, not only by looking to reasons for the decision, but also by gauging the objective consequences which the decision occasions to some or all of the beneficiaries. And then it goes on to quote Hampden, Earl of Buckinghamshire. And it's summed up at the end, has the fiduciary intended to act in his beneficiary's interest? Has he in fact acted otherwise in their interest, viewing the consequences of his decision objectively? And that is the overarching test that applies when a power is exercised, notwithstanding that the power may be a wide one on its face that might permit anything. I'll come back to another example of that in due course, but I'm mindful of the hour. I'm conscious we had a late start. I don't know whether your Lordships and your Ladyship are prepared to make up the 10 minutes and for me to carry on at this point, or whether you've had enough for today.
I think if you're running short of time, I think we can consider starting slightly earlier tomorrow morning at 20 past. Would that be?
I would certainly be grateful for that,
Yes,
my Lord.
I think expanding your arguments at this stage probably might not be as productive.
Indeed. It may be of assistance to help me overnight if there are any particular issues arising from my written case which your Lordships were intending to grill me on tomorrow. If not, I'll proceed as I planned.
I think, looking at my colleagues, you proceed as you plan.
I'm obliged.
The court will now adjourn and will resume tomorrow at 20 past 10.